In this video, we're going to have a look at intention to contract, or more specifically, intention to create legal relations. Now, just an overview of intention before we start looking at the assignment itself. And in the intention area, we need to consider these things down here. Firstly, the relationship of the people. There's a presumption we apply, and with presumptions, we can rebut these if there's evidence to show they're wrong. The test we use is a reasonable person considering all the facts. Would they expect a contract? So let's start with the issue of the relationship of the people. So we've got two options here. We can either have a social or domestic situation, which is family, friends, or we can have a business or commercial situation. And this is the one you'll be dealing with in the assignment. The presumption is very simple. No contract and contract. So that means we have a starting point that if we're in a social situation, there's no contract. And so if you have a family arrangement and you have a breach of that family arrangement, you want to sue your family members, then the starting point for any court is that you don't have a contract, so you can't sue them unless there's evidence. Now, what sort of evidence in social situations? Well, a lot of money, a lot of property, a lot of time, things that in reality look very much like business or serious situations. A number of cases have involved lotto winnings. Now, the problem we have, however, is over this side, which is to do with commercial situations. Now, the first thing to say is it's difficult to do that. It's very difficult to prove. And the real way to do this is really to use specific wording. Now, we could do this orally, but that creates proof problems. So really, if you want to avoid contracts in commercial situations, you have to default back to putting specific wordings in agreements. Now, in the assignment, you're going down this track over here entirely. So we're going to focus around here. And the assignment's asking you to consider in the situations where you would need to use specific wording to rebut the presumption of the contract and to draft a clause which is suitable for your business. Okay, so let's have a look at the assignment itself. Now here we have the wording out of the assignment, and what are we required to do? Describe a contract with a supplier. So it's about a supplier here. Now you may use a customer if you have a business where it's more applicable, such as construction. For most people, we may be looking at taking long-term supply contracts, or as I said, with some of the businesses, your customers would be acceptable for long-term contracts. The point is you need to enter into negotiations with them. Day-to-day contracts, you don't normally do this. What you're going to do is apply the law of intention to create legal relations as just set out, and come up with a communication you can use in the negotiation phase. So this would go on whatever communication system you're using for that purpose. Okay, so let's move down to look at this question specifically. How do we actually rebut the presumption of an intention to create legal relations in commercial circumstances? And as noted here, you do this for business situations, so don't consider the family issues that might arise. Now, the case where this is most well known is Rose and Frank and Crompton and Brothers. This is where the courts first discussed this to any extent, and this was the actual clause they used, that the agreement shall not be subject to legal jurisdiction, and agreement is not entered into, nor is a memorandum written as a formal or legal agreement. And I've really stuffed that one up. Okay, so let's just turn to this with a bit more specifics about the question of rebutting the presumption in commercial circumstances, as that's what you're doing for business situation. You are not looking at the family issues in this assignment. The case where this started was Rose and Frank and Crompton Brothers. It's an old British case. And if we read through the clause, the courts have made a statement about clauses which are referred to as honour clauses. where each person honorably pledges themselves with the fullest confidence. So let's now turn to looking at the specifics of rebutting the presumption in commercial circumstances, which is what you're doing in the assignment. The starting point for this was the case of Rose & Frank and Crompton Brothers, and the language is fairly Old English. However, you'll see this arrangement, the negotiation, is not entered into as a formal or legal agreement and not subject to jurisdiction in law courts, but as a definite expression and record of the purpose and intention of the parties to which they honourably pledge themselves. So the key words down there is that they honourably pledged themselves. And the courts interpreted this as showing they did not intend a contract, just to have an agreement which was honourable, meaning it could not be enforced. Now this type of wording would be quite unacceptable today for most people and rather confusing as well. So we tend to default to much simpler approaches to this, and these are three simple examples. So we have subject to preparation of a formal contract, subject to contract, and subject to contract of preparation of a formal agreement. These are acceptable, but they're not actually bulletproof in a legal sense. The courts have looked at these types of very simple clauses, and where the behavior of the parties and their actions show a contract, there will be a contract. And so if you put a clause like this into your communications, and subsequent to that you start sending goods, sending invoices, and taking all the normal actions of contract, then the courts will simply say you had formed a binding contract. And that will apply no matter what your clause is, but it's more likely where you have very simple clauses. That's not to say they're not useful. They are useful. But if you want to be certain, you need to be a lot more specific. So here's one longer example. So no communication in any form shall operate to create a binding contract until the supplier, which is you for example, or you could be the customer, shall provide a written quote in its standard form, and the other party shall accept by completing the acceptance of quote form attached to the quote. This goes a little bit beyond just intention, but it certainly makes the point that no contract is being formed until a formal process is followed. Whereas up here it refers to the formal process, down here it sets out the formal process, which makes it much better. Referring back to the previous video talking about incorporation of terms, requests, counteroffers, a clause like this is also very useful to avoid the issues to do with counteroffers. A much wider type clause which could be used in long-term negotiations where draft contracts are often provided would be such as here, where it's saying this agreement is intended to provide the basis for further work, discussion and release of information for the purpose of establishing a commercial relationship. So although it doesn't say no contract, it's making it very clear these are preliminary negotiations for the purpose of creating a contract. So what you need to be doing with this assignment section is to set out the contract you could enter into. It should be a contract where there is a good reason where you would want to avoid a contract until you've gone through a formal process. Draft up the clause and indicate where you would put it in your emails, letters. You may indicate you want to use quotes. And today, for something completely different, finish with a picture of Temple View, which is just out of Hamilton, from the cockpit of a flying motor mower, otherwise known as a Bantam. Okay, and so today, since it's a nice day outside, we'll finish with a picture of Temple View area, which is just to the southwest of Hamilton, taken from a flying motor mower. Okay, so today to finish with something completely different. This is a picture of the Temple View area southwest of Hamilton at about 1,200 feet, taken from a small aircraft akin to a flying motor mower.